This complaint occurred in Maughan in Melbourne, an area which is now fully developed and an affluent suburb. At the time of this case it was unfenced land where anybody might graze their stock. Maughan was in the habit of allowing his horses to graze in this area. Hutchins, on the other hand, was a drover who wanted to move 2,000 head of sheep through the area. Maughan laid poisoned baits in the area. We know it was unlawful for him to do this, but the case doesn't tell us precisely what his motives were. There's nothing to suggest that he was deliberately trying to make life difficult for Hutchins. He then went as far as to tell Hutchins that he had laid baits in the area. Hutchins thought he was bluffing about the baits. He checked and didn't see any, and then drove his sheep into the area. His 2 sheepdogs then took baits and died. He sued for damages. By the time the matter got to the Supreme Court, the only cause of action being pursued was an action in trespass. He was alleging that Maughan had trespassed against his possessions, his dogs, by laying the baits. The problem was that the nature of trespass usually involves direct and intentional conduct. Is that what occurred here? The court said no. Chief Justice Herring said the baits were laid by the defendant before the complainant took his dogs onto the land in question, and had he chosen not to come into the vicinity and bring his dogs with him, he would have suffered no injury from the defendant's act. Had the baits been thrown by the defendant to the complainant's dogs, then no doubt the injury could properly have been regarded as directly occasioned by the act of the defendant, so trespass would lie. As it was necessary for the complainant himself to bring his dogs with him to the baits in order that the injurious consequences should result. From this case we confirm that trespass requires that harm should be directly caused by the act of the defendant. If the defendant's act does not in itself cause harm, but requires some further conduct by someone else before harm can occur, then the tort of negligence will not be proven, and some other cause of action such as nuisance or negligence will be a better option.